You're listening to Talking Law, the podcast where business owners just like you discover how to avoid legal landmines and build value using smart legal tips.
Hi, it's Joanna Oakey here and welcome back to Talking Law, a podcast proudly brought to you by our commercial legal practice, Aspect Legal. Now, today we have something a little bit different, a little bit less serious than our usual Talking Law podcast where we give you the latest tips and tricks in law. Today we are talking about COVID and scandalous trademarks, some things that maybe you wouldn't have expected, some things that have come to light that the fabulous Gracie, who heads up our trademarks area at Aspect Legal, has recently identified as something she thought was rather amusing and wanted to share with us. So Grace, thank you for coming back on the show.
Thanks for having me, Jo.
Brilliant. Okay, all right. Well, you and I just can't get enough of talking about trademarks, of course. And while we find this topic very interesting, who knows if our listeners will as well. It could just be a little geeky thing that we geek out on trademark law. But I was fascinated by some of these things you were telling me about marks that had been recently registered. And gosh, I must say, I'm actually blown away by the creativity of some people. I must say, when this whole pandemic hit, getting a trademark related to COVID was not at all on my mind. So, and we work in trademarks, well, and particularly you, Grace, day in, day out. So some people out there are very creative, right?
Absolutely, yeah, it's amazing.
So give us a walk through some of the entertaining things you've seen recently with trademarks.
Yeah, so amazingly. So we, as you know, global pandemic hit March in Australia. And interestingly, as soon as we hit mid-March, we started getting trademarks being lodged on the trademark register here in Australia for COVID-related trademarks.
From mid-March. That's really early, isn't it?
Yeah. And it's something that's not just happening in Australia. It's been happening internationally. So it's happening in China. It's happening in America. It's happening around the world. So here we go. I've got a trademark here for Corona Clean.
Corona Clean. That's quite clever.
Detergents and disinfectants lodged on the 3rd of March. How early is that? That's before lockdown.
That's amazing. That's when we're all still in denial. Well, other than this very creative person. Wow.
So
okay.
Yeah, people have tried to lodge coronavirus.
Really, coronavirus? Oh, for an app, right? Okay.
An app.
Well, what kind of app was it? Do you know?
Don't know. They've just lodged it in Class 9 for apps and software.
Interesting.
Class 41 for education.
Wow. So what was the 41 one?
Yeah, for education and entertainment for the word coronavirus.
Oh, for education and entertainment.
Yeah.
Goodness gracious me. I wonder what they were up to. That's interesting.
Who knows? Coronavirus resistant for cleaning products and household cleaning products. The quarantine concierge.
Wow. And what's that? Is that cleaning again?
Class 39 for the delivery of goods.
Oh, right. Quarantine concierge. Okay, that's really clever.
Yeah.
So tell us, Grace, how did all of these marks fare? Did any of them get through?
Well, they're all now that it's we're into May, end of May. All of these marks, most of these marks are under examination, which means that they've received some kind of adverse report from the Trademarks Office.
Yes.
I can see one of these has been accepted, and it's probably because there's enough material in it to not be descriptive. So we'll talk about what these marks are probably facing without asking for access to the reports under FOI. We can't see them, but we can guess based on, other sorts of controversial marks that have been lodged in history.
And let's step through that in a moment because I'm very interested in the controversial marks in history. But stepping back one, what are the reasons that you think there might be issues with some of these marks that are all being held up in the adverse report phase at the moment?
So there's two main issues. One of them is that in the trademarks law, there's actually a provision that prevents trademarks from being accepted for registration if they contain or consist of scandalous matter, or if its use would be contrary to law. So that's when we get a little bit technical and lay out what the provision actually says. But really, it's there to protect. It's there to give the registrar the ability to say, no, we can't accept that trademark. It's just too scandalous.
Yeah.
Yeah.
And you know, I guess some of the potential issues with the registration of Corona or marks including the word Corona. I mean, firstly, we have a really strong brand, albeit in beer, for Corona, which is...
Yes.
So I guess that's, you know, potentially if you're anywhere near whatever the registrations are for Corona, the beer, you're likely to have that cited. But I guess in many senses, Corona is becoming quite descriptive now, perhaps. Is that something that you think might be an issue here as well, Grace?
Absolutely. So, yes, a lot of these marks, the second issue that they're going to face is that coronavirus, COVID-19, all of these sorts of terms are very generic, descriptive terms that everybody is using at the moment to describe a virus. So to say that someone can own it and monopolize it and have the right to exclude any other trader from using it would be contrary to the spirit of the trademark law.
But which was the one that got through, Grace? You said one has just been accepted.
Well, it looks like, it's been accepted. And the mark was eHealthier's interim COVID behavioural vaccine.
Right.
So there's enough material in there that as a whole it's got enough.
Yeah, I see. I'm really interested to see how quarantine concierge. I'd love to I'd love to know how that one goes. Maybe that one has a hope. I'd be interested to see what happens with that. So people can be very creative, can't they, Grace?
Yeah, absolutely. The fact that there are people out there as soon as the pandemic hits, they put their entrepreneur hats on and think, how can I monopolize on this? That's just amazing, right?
Yeah. And I guess one of the takeaways in this that, we've been discussing is that it's quite clever for a business to think when there is a lot of attention to a particular area to think, how is it that I can use brand and then through trademark registration brand protection to have something that is really clever and will be picked up in the discourse that's just out there at the moment.
That's right.
And I think that's super clever. But the point is, if you want protection for this, then you need to do it in a way that complies with our trademark laws here in Australia.
Yeah, this is a bit, I don't know if we should talk like this, but if some of these marks wanted to get up, these COVID marks, it'd be about adding something to it that makes, as you say, is clever, using a turn of phrase or a pun or a play on words and adding something to it to make it really distinctive and to stand out. That's what we're talking about to get it across the line.
I think, and actually, how about a challenge to you, Grace, is to keep your eye out and see, maybe we'll have an eye out for the cleverest mark that is actually able to make it through the trademark registration process that has some reference to this pandemic we are currently living in and fairly obsessed with. So we'll look out for that. How about we do that? And you, our listener, why don't you join in? This sounds like a fun game. Why don't we'll just throw it out there. If you send in to info@aspectlegal.com.au any entries you have for this game. We want to know the most creative, bizarre, I don't know, the most amazing trademark registrations, I guess, that relate to COVID or quarantine or coronavirus. So throwing it out to you and we'll report back. How about we report back maybe in a few months, Grace, on on what we've seen, whether we've picked up and whether we've found a winner. Well, they won't be through the application process, I guess, in that time. For listeners who aren't aware, the minimum period of time for processing a trademark application from the date of application through to actual full registration is it still 7.5 months, Grace? 7.5 months. So anyway, we may need to give it a few more months. But anyway, we can just go on the basis of applications at the moment. I'm interested to hear in the creativity of trademark applications. So there you go. We've got a bit of a contest out there. And look, the person who submits something that we end up deeming to be the most creative will win a bottle of champagne. How about that? French champagne. We're throwing it out there. So go on, get us your applications, and otherwise Grace will be on there. She'll be looking as well. So,
well, I'll put my hat in the ring.
Oh yeah, have you got one? Another one now that you haven't told us?
There's one that was lodged on the 2nd of May for coronavirus sucks.
Okay, I like it. Wow, you're really close to this bottle of champagne.
It was lodged in 7 classes, Joe.
Okay, well, tell us what does coronavirus sucks do as their goods or services?
Well, this person wants to use this brand on phone covers, stickers, bags, cups, tea towels, clothing.
Wow.
Buttons, badges. It's merchandise. It's coronavirus sucks merchandise.
Wow. Okay. Interesting. Well, I don't know. Let's wait and see if that one gets through. All right.
Yeah.
So you mentioned, Grace, as we first started talking, that there were also some other controversial marks through history that you'd seen that gave us a little bit of an indication of how some of these corona trademark applications might go. I want to hear about those. What have you found? What have you dug up in the trenches of our trademark journals?
Yeah, so we can kind of guess what's going to happen with these corona-related trademark applications because we've seen it happen before. So if you recall back in 2014 when that Malaysian Airlines flight MH370 went missing. Amazingly, 2 trademark applications got lodged very soon after the flight went missing, actually, for that flight number.
Holy cow.
Yeah, for MH370 in Class 41 for various entertainment and education type services. And that application actually went all the way to a hearing.
Wow. Yeah.
And so I guess one of the reasons why the examiner would have initially knocked it back was because of it being scandalous. But at the hearing, it was rejected on the basis that it was descriptive. So this is how we know that these 2 issues are in play. It was the airline itself that lodged the application.
Oh, right. So Malaysia Airlines lodged the trademark application here in Australia.
So MH370 was lodged by a company called Aon International Proprietary Limited. And then in July, MH370 was lodged again by Malaysian Airline System.
Right, I see.
A Malaysian company. And they lodged it in Class 9 for all different types of scientific products, Class 16 for books and paper products, and Class 41 for education. And their reasoning for lodging it was that they were going to use the brand to educate the community about the flight that went missing.
Wow. It's interesting. I think organisations sometimes take the approach of trademark registration in a defensive way in that they want to try and ensure that no other organisations will end up with a mark, even if their future usage is limited. And, of course, it's really important not to register a mark that you intend never to use because, and you do have a grace period between registration and between having to have used a mark, but if you haven't used it within the first 3 to 5 years, is that right, Grace?
Yes.
Then you are exposed to another company making or another organisation making an application or someone making an application for removal of the mark on the basis that you haven't used it. So it's important if you register a trademark and you intend to keep the protection, that you use it in some way. But certainly it's a valid reason for trademark registrations that we've seen organisations take, that they might take out a registration in order to ensure that other organisations don't end up with that monopoly right rather than them.
And in the whole time that we've been working on trademarks, I can only recall one instance where it was really clear that there was no intention of using it, and I don't think we went ahead with lodging that, because you've got to have that intention to use.
Which is important for people to be aware of if they're thinking about trademarks from this more defensive mode. But I guess you can meet the tests of use sometimes quite easily. So anyway, if that's something that you're thinking about, you should certainly take legal advice. Someone who knows what they're talking about, so they can talk you through how it is that you can ensure that once you have a trademark registration, you don't lose it on the basis that you've failed to use it in the proper way. So, okay, so did any of these MH370 marks get through, Grace?
No.
None at all. Okay, even the Malaysian airline ones didn't get through. No. Okay, interesting. It is interesting because obviously that was a flight code of Malaysian Airlines. So it does bring in interesting discussions, and certainly is an excellent reminder, I think, for organisations when they're choosing brands to think very critically about whether or not those brands can indeed be protected by way of a trademark registration before they throw a whole lot of money into it, if they might want to have that protection, because we have seen time and time and time again, organisations go through the creative process of coming up with a brand, only later to find that they're completely surprised that they're not going to be able to get protection for it, because they've put the cart before the horse, because they've done the creative process and committed to all of that without having the legal step also taken, which is the assessment of whether or not it's a registrable mark. So that's an interesting one, but not necessarily on point for our discussion about controversial marks. I want to hear more of the fun stuff, Grace. What else have you dug up there? I want to hear it all.
Do you want to hear some really unusual marks?
Please.
I mean, gosh, in the time that we've done trademark work, we've never had clients come up with, how shall we say, colourful marks.
Well, we've had colourful marks, but maybe just nowhere near as colourful as you're about to talk about here. I think that's the...
I'm blushing even thinking of saying this out loud.
Grace, tell us.
Here we go. We're adults here. This is M-rated. This podcast. There's a mark on the register for Nucken Futs.
Oh my goodness! Well, what's that for, Grace?
For nuts and snacks.
For nuts and snacks. Okay. Well, that's certainly creative, isn't it? And how did you say it's a mark that's on the register, or just a mark?
Yeah.
So that's it. It got through.
It got through. It's registered. It's been registered since 2011. But the interesting one about this one is it's got an endorsement, and an endorsement is something that goes on the register. It's quite often we'll see endorsements like the trademark owner does not claim exclusive use, and then it'll have some very descriptive element of the mark. Or what other endorsements have we seen, Jo? The trademark owner will never use the cross symbol in silver and white or red on a white background, because that's owned by the Red Cross. Yes, we've seen that.
We have seen that, yeah.
But this trademark's got an endorsement on it that it's a condition of registration that this trademark will not be marketed to children.
Gosh, that's interesting. I've never seen that sort of endorsement before. But there you go. The Trademarks Office has been very creative here about how they work through an application to a point that they feel that they can actually register it. What else have you got?
There's a trademark on the register for Pommy Basher.
Goodness gracious. And that got through?
That got through for clothing and drinks. Beer.
Goodness gracious. Wow, okay.
Yeah.
And did this one go to hearing, or did it get through without a hearing?
It actually did, and it was accepted because the decision maker decided that this is a word that's just colourful and colloquial and acceptable.
Right. Okay. Well, there you go. And we have had some discussions about some more colourful language, as we've been discussing before. One of the marks that you're going to talk about, I don't think we can even say, but perhaps we can spell it out, Grace. You spell it out rather than saying.
It's probably the most offensive word in the English language, and it's this person has decided to lodge a trademark for a misspelling of it. So they have spelt it KUNT.
Right.
So the one that's currently on the register is for what we would call a composite mark. It's got some elements of words as well as images.
I'm not sure I want to know what the images are. What are the images, Grace? I guess tell us. Now I've asked, I'm interested.
So the image is of actually, I would say it's a skull.
Oh.
Wearing a top hat.
Right.
And smoking a cigarette.
Okay, that's unusual. Okay.
Yeah.
Right. And what are the goods or services protected by this mark?
It's for clothing.
Right.
It says in the claim, apart from just general clothing, motorcyclist clothing.
I see. Okay.
Yeah.
All right.
And the word elements are what? So you spell it WOT and then KUNT ? Clothing. And it's currently under examination, so we don't know yet if it's going to get through. Oh, it received an adverse report.
Yes, unsurprisingly. And, of course, we've got a lot of F-related marks.
Can we say these? I don't know if we can say it.
Maybe not, but let's just say we've got to. I've got to say the funniest one in this list that you've got there, Grace, is fuckaware. I thought that was quite funny. Is that for? I'm presuming it's not in a class that Tupperware is in. What's that one for?
It's in class 35. And I'll just read out verbatim what they've claimed. They've claimed direct marketing and selling of adult products and sex toys via parties. I'm going to cry now.
Oh, stop. Oh, that's too funny. Some people are very creative. Okay, well. Oh, dear, oh me.
Oh, dear, I'm so sorry.
And is that one, did that one get through? I'm interested to know whether Tupperware...
It's been around since 2002.
Really? And there was no... Can you tell if Tupperware opposed it?
Oh, no one opposed it.
Yeah, right. Okay, I guess, it's quite possible that their trademark search didn't contain some of the elements that were in this mark, but obviously some sort of phonetic similarity. Okay, wow. Okay. Well, look, Grace, I tell you what, you've given us the goods today. This is actually I've enjoyed having a bit more of a lighthearted discussion about trademarks. But look, there's some serious points in here. I guess the first serious point is be aware if you're quite colourful with your language or your marks, you might very well face issues with trademark registration on the basis that they're too scandalous. So I guess that's just one possible learning out of all of this. But I guess the other, the thing that really has struck me from this conversation, other than trademarks can be quite amusing, the word of trademarks, is the creativity of some people, and really I just think it's very clever to adopt the idea of when the mind of society is turned to a particular subject, finding a way to incorporate part of that subject creatively into a mark that you then take brand ownership of, and then are able to get protection for, is very clever, I think. And, and maybe there's a note in there in terms of how in business we can think more creatively about brands that we're using for products or services to not just, number one, take advantage of where the discourse is and what everyone's thinking about at the moment, but also how to do it in a way that is actually protectable so that we're able to build monopoly rights for ourselves.
Yeah. And I think that's really important because we spend so much time with our clients and I just see it. I see it in their eyes when they finally cottoned on to how important having their brand is protected. Yeah. And I think that when the penny drops is when they're at that risk of infringement. They're facing. They feel exposed because there's a competitor in the market who's come up with a name that's just too close for comfort. And they come to us and they realize, really, if you're going to go into that battle with somebody else and you need to shut them down or you need to get that name off them, if you don't have it protected, it's literally like going to battle with no armor.
Absolutely.
Yeah.
And time and time again, we'll have these discussions with clients and we will say, you need to hold fire. We need to get our protections in line quickly first because timing is everything in trademarks, and it's particularly difficult when a competitor has gotten in first and blocked your path. We've seen some really sad stories relating to this, Grace, and over our many, many, many years working in this area. So it's not hard, but you've got to be quick, I guess, is the point, and tackle it early. And right back at that creative phase.
That's right. Yeah. So we've talked about something a little bit funny today, but I wanted to use something like humour to get the issue back in front of mind because I think these people are funny, but, we're having a laugh, but they get it. They understand what the trademark registration system is about.
Yeah.
And I feel like if we can use this funny story to bring the issue back to front of mind for our clients and our listeners, then I feel like we've achieved something today.
Yeah, absolutely. As well as having fun. I've had fun. Yeah. Have you had fun, Grace?
Oh, we always have fun, Jo.
We do. Well, look, I hope you, our listener, had fun as well, seeing the lighter side of trademarks, but also perhaps having a bit of a dawning of how some of the things we're talking about today might actually be really relevant to your own businesses in terms of not just your own current protection, but also how you approach branding into the future and the integration of considering the legal elements as well as the creative elements all together.
Yeah.
Brilliant. Love it, Grace. Thank you so much for coming on board with your fascinating information.
And you know what? I really feel like we've done our job when we get to a stage with our clients when they are at that brand development stage, and we've talked about this so much that they just know, I've just got to run this past Grace and Jo and see what they think. And quite often we can just help them tweak it just a little bit and then we can get it protected straight away. So it's just that insurance for their marketing.
Yeah. And that can also make the difference between, number one, something that they can protect, so the marketing spend is protected, but also that we're helping them to make sure they're not exposed to future infringement actions. Because there really is those two elements here. It's that ongoing risk that organisations don't understand they're running and the failure to protect those key assets that they're just really not clued into. So there's the serious side of a more funny story. Very Grace, thank you so much. Loved having you on board. Well, that's it for our episode with Grace Yee from Aspect Legal, all about COVID and scandalous trademarks and other creative ideas of how to use trademarks and brand protection in creative ways. If you would like more information about this topic, for example, if you were so interested and you want to download a transcript of the podcast episode to read it in more detail, then just head over to our website at talkinglaw.com.au. There you will also be able to find out how to contact Grace and our other fabulous legal eagles at Aspect Legal if you or your clients would like help with any trademarks that you're looking at protecting, or indeed any brands that are in the creation phase that you'd like some legal input into in order to ensure that you end up with a trademark at the end of the day, or a brand at the end of the day that is protected and protectable. Well, thanks again for listening in. You've been listening to Joanna Oakey and Talking Law, a podcast proudly brought to you by our commercial legal practice, Aspect Legal. See you next time. Team at Aspect Legal specialises in providing trademark registrations and general advice on brand protection and commercialisation for companies and individuals based anywhere in the world. So if you work in creating brands or logos for businesses, or if indeed you're a business needing assistance in protecting your brand, we offer a free 15-minute consultation with one of our lawyers to discuss how we can help you or your client. We also provide free trademark packs if you want to get a bit of an understanding of the process and the timelines. And of course, we do more than just trademark registrations. We work with our clients on a range of issues to assist them in making their trademarks work for them. So if you want to find out more, pop us an email at trademarks@aspectlegal.com.au or head over to our website at aspectlegal.com.au to book in a free consultation with one of our specialist lawyers.
Thanks for listening to Talking Law. Tune in next time for more smart legal tips and tricks to keep you clear of those legal landmines. If you want to get a download of today's show notes, head over to talkinglaw.com.au.
Are you looking for a top quality legal team to assist you in your organisation? Aspect Legal is an innovative commercial legal practice that specialises in providing fast and professional services for their clients. If you'd like to chat about how we might be able to assist you, simply head over to our website at aspectlegal.com.au to book in a time for a free discussion with one of our lawyers.